Hey, this is Washington attorney Ryan Witt. In a criminal defense law firm, we hear all kinds of issues, but the one that causes people probably the most dismay is Washington's mandatory arrest rule in domestic violence cases. The reason we know this is on a weekly basis, we get a number of domestic violence calls. Now, a lot of them are not from the defendant. They're actually from the alleged victim, the person that initiated law enforcement contact. And they'll tell us, my boyfriend, my husband, my girlfriend, he's been taken to jail. Oh my gosh, I said some things I didn't mean. A lot of what I said wasn't true. How do we make this all go away? And I have to have that very hard conversation with the person that, the process has started. And really, in Washington state, the state drives the charges. It's not the wishes of the victim or the alleged victim. So the person has to go through the whole process. Now, there's so much question about, we get about why is this mandatory arrest rule, the way it is. And even when I was, 20 years ago as a practicing attorney, I didn't necessarily know what drove that rule. But what it is, after doing this for many years, is it's a combination of two statutes in the RCW. RCW 1099-030 states when a police officer responds to a domestic violence call and there's probable cause, they shall exercise their arrest power. And then RCW 1031-100 states that within the preceding 4 hours, if the individual assaulted a family or household member, they shall be arrested. So I'm paraphrasing that a little bit. The full statute is on our blog, on our website, but that's what it is. If there is a call within 4 hours and the officers arrive and they think there's probable cause that an assault took place, they must take an arrest or make an arrest. And if they don't, they can be in trouble later upon review of the decision to not arrest. So they will almost always make an arrest. Now, the quantum of evidence needed is actually very low. And this is, I think, what's surprising to people. The police are not going out there responding to a call to get to the ultimate truth of the matter. What they're doing, responding and knowing that they have to make an arrest, is they're gathering evidence. They're just gathering evidence to meet a burden of probable cause for arrest, much lower than beyond a reasonable doubt for a conviction. Officers can make a finding of probable cause basically just on, it could just be what's said in the 911 call. It could just be, what an individual says and then, almost instantly retracts it. It could be statements that are made by an individual that's obviously highly impaired or motivated by other things like anger or jealousy. Who knows? But when people make allegations against somebody else and it's within 4 hours, typically it's going to be an arrest, almost always. And that just is mind boggling to most people. So if you're in that situation, we have a lot more information on our blog and on our website in general. But first and foremost, don't add anything to it. If you're being interviewed by the police, best to just contact an attorney. And if you're in Kitsap County or surrounding areas, we take all these calls and we take them 24 hours a day. Numbers 360-792-1000. Thank you.